Colegas.
Colleagues, let us resume our session. I would like to take note of the fact we are now in public session. This is meeting 2322 of the Committee on Human Rights, and this is a public session, I remind you. Recently, the committee has been looking at individual cases, communications, we call them, under the optional protocol, and we always do this, as you perhaps know, in closed session. But when we look at general comments, then we work in a public session, and that's why we'd like to wish a very warm welcome to those with us this afternoon. I should like to remind you we are currently working on the draft General Comment 36. This is our first reading. Let us read it through slowly. There will be a lot of discussions and contributions, but I believe we are working effectively. The two rapporteurs, Mr. Shani and Sir Nigel Rodley, to facilitate things, they are sitting together so they can consult, if necessary, more easily. If they need to give responses or react to comments from colleagues. So I'm going to give the floor to them, Mr. Shani, Mr. Nigel, the rapporteurs, to tell us where we are at this current point in time. Thank you. You have the floor, sirs.
Thank you. So as you have noticed, we are developing into a two-headed monster. Slowly but surely. So let's go back to where we were. We had provisionally adopted paragraph 1 with the understanding that we may have to return to that after discussions on other provisions. And we have quite thoroughly discussed paragraph 2, 3, and 4. And the outcomes of these discussions are reflected, we hope, in the draft that was circulated yesterday, and which we will go by paragraph, and we will explain what changes have been made in reaction to issues raised by colleagues on the committee. We've already been appraised by some members who would like to propose some small changes to the language of paragraph 2, 3, and 4. We also added, as you would see, a paragraph 3 bis, which was, again, a reflection of the discussion that we had. So I think for us the safest course would be now to proceed paragraph by paragraph and to continue to try to adopt these 4 paragraphs, and if time permits, continue with paragraph 5, 6, and maybe 7. So with respect to paragraph 2 was already discussed during the meeting we held on Wednesday. The one remaining issue that was left open was the request by one member of the committee, Mr. De Fruville, I believe, that the paragraph would include some reference to the linkage between the right to life and other rights. And as a result, you have before you a text which I will now read slowly. I will read the last sentence of the paragraph, which attempts to accommodate this specific concern. So the last line of the last sentence of paragraph 2 reads, "It is most precious for its own sake." This is something that was already there. As a right that inheres in every human being, but it also constitutes a fundamental right whose effective protection is the prerequisite for the enjoyment of all other human rights. And here comes the new language. And whose content can be or is informed and infused by other human rights. Again, and whose content can be or is, we will have to choose between the two formulations, informed and infused by other human rights. So before returning the floor, well, before Sir Nigel will take the floor, I believe that there was one proposal that Madam Waterval wanted to make with respect to this. So the chair can grant her. So I remind you, Madam Waterval, that you wanted to make a proposal which the rapporteurs already announced that they are favorable to. Thank you.
Muchas gracias.
Thank you very much, Mr. Shani. So, Nigel, would you like to add anything?
Just purely to explain why you have the alternatives in square brackets of can be and is. Otherwise, and I agree with everything Mr. Shani said. And the point of the alternatives is that one is more capable of reflecting an approach than another. Can be is less dogmatic about the extent to which other human rights are relevant for the interpretation of the right to life. Is more dogmatic about the extent to which other human rights can be read into the right to life. And so that is the point of the distinction. There are the two trends in the committee. We didn't feel we could quite capture language that entirely reconciled them, and so it may be that we just need to have a quick expression. I don't think it requires. If one or the other will satisfy everybody, then it probably isn't worth a long discussion as to which we choose. But that's the explanation for the choice being left in square brackets. Thank you very much.
Muy bien, muchas.
Thank you very much. I have Ms. Waterval on my list, and I'd also like to call on any other colleagues if they should like to take the floor on this matter. So the first speaker, now that I'm opening up the floor, is my dear colleague, Ms. Waterval. You have the floor, madam.
Thank you, Mr. Chair. I had a friendly proposal for the two rapporteurs, and that is to replace the word war in armed conflict. So that was it. Thank you.
Muy bien.
Thank you very much. I see already the two heads of the rapporteurs together, consolidating their reply, as Mr. Shani said, like a two-headed monster, in the nicest possible way. Mr. Politi, please.
Thank you, Chair. I would like to react immediately to the suggestion made by Ms. Waterwall. I think that it's a good suggestion to replace war with armed conflict. And as far as the last expression, let's say, or series of words is concerned, I would go for the less dogmatic alternative, but I would like to have some more clarifications about the difference between informed and infused. It would be interesting to hear what they mean exactly, whether there is a difference, and why we have two expressions in there. Thank you.
Bien. Señor de Fruville.
Mr. de Frouville. Thank you, Chairman. Thank you for these proposals. I've understood that we're just working on the new paragraph 2 for the moment. We're not looking at the other paragraphs, are we, yet? Okay. I completely agree with Ms. Vattenfall's proposal. I think the term armed conflict is the right one today in international law to talk about what we want to get across. Now, on the proposal from the rapporteurs, well, I thank them for that. I think it does indeed allow us to incorporate the idea which was expressed by several different members' comments in the previous discussion. Now, for my part, I was thinking about something a little bit more specific, and I don't want to insist, because I think the proposals at this stage are welcome. But I just wanted to come back to the importance of recognizing a twofold conditionality, the right to life and the right to enjoy other human rights, that the prerequisite for the enjoyment of all other human rights. That's clear and evident, but it's true that other human rights are the condition for effective enjoyment of the right to life. Let's take the case of enforced disappearance. When someone is entirely deprived of their right to freedom and security, or closed in a secret detention center, you're at the mercy of your captors. And then the right to life, there's not much really left. In a way, the deprivation of the right to life and the right to acknowledgement of the natural person, that will, of course, impede the enjoyment of the right to life and will, in fact, endanger it. So this relationship works both ways. And it's perhaps important to highlight that. We might take the example of economic social rights when you have a state which doesn't react, for example, to an epidemic, which fails in its obligation to disseminate vaccinations which do exist in the face of an important epidemic, then they are failing in their vital obligations in terms of the right to health, for example, and are therefore endangering people's right to life. So that's the meaning behind interdependence and this dual conditionality. But I won't insist. As I say, I do understand the rapporteur's proposal.
Muy bien, muchas gracias.
Thank you very much. Mr. Benashaw, please.
Ah, no. Bueno, estaba apuntado.
No, you were on the list, but fair enough. Ms. Seibert, please.
Thank you very much. And I would like to thank the rapporteurs for constantly changing and amending it in line with the discussion. I think the paragraph as it now stands very much reflects on what we had discussed over here. I think I'm in favor of it. I would rather go with can be informed and infused by other human rights. I understand what Monsieur de Frouville just outlined, but I think you have specific cases in your mind which may be better taken care of in the rest of the paragraphs when we come to enforced disappearances, for example. I think the purpose of paragraph 2 is to be very general, and I think the notion is there, and then if we come to concrete examples, I think we should spell it out over there. Thank you.
Bien, muchas gracias.
Thank you very much. No other colleagues appear to want the floor at this stage. So I will give the floor back to the rapporteurs for them to react to what colleagues have said.
Thank you very much. As indicated before, we are in agreement with the proposal made by Madame Wattoval. So we will change war to armed conflict. And with respect to can be or is, as Sir Nigel said, we were basically allowing for both options. The members who spoke in favor of can be, and we are very comfortable with this proposition. With respect to the question of Mr. Politi, and this is somewhat related also to the intervention by Mr. de Frouville, in our mind, the notion of inform is a more technical notion which basically delineates the scope of the right. So for instance, we will come back later when we discuss the scope of the right, that in a way the right to life is defined, its scope of application in relation to other rights of the covenant, and also, of course, some key terms are defined. But with the term infuse is intended to convey the meaning that Mr. de Frouville alluded to, that actually it gives it meaning. They actually penetrate into the substantive contents of the life. So that's why we chose a more technical term, which allows us to understand the legal meaning of the right to life, but a more substantive term which would give it content. And I think that reflects that tried to reflect the concern, and I think it does. Thank you.
Bien, muy bien. Muchas gracias.
Okay, thank you very much. So I think then we might be in a position to consider adopting this paragraph, accepting Ms. Vattenfall's proposal and using the term can be. It's not my preferred option, to be honest. But of course, when we adopt a general comment, nobody has a veto. We have to try and capture the general feeling, the general sense. Otherwise, it would be impossible for 18 people to completely agree on every single word. So we have to take into account the general sense, the general meaning. And so on this idea, I understand that Mr. de Frouville will accept, and I will also accept, the inclusion of can be instead of is, at least on this first reading. And if so, we can approve this paragraph. This will be the first paragraph we've approved in the general comment. It's quite an exciting moment. Mr. Mamusa, sorry, I didn't see your flag. Mr. Mamusa.
Yeah, thank you very much. And this is another case of friendly fire in times of war. But having dropped that word, maybe and replace it with armed conflict, we could bring it even better. Instead of times, we say in situations of armed conflict. But this is something that the rapporteurs could look at, and thank you.
Bien.
Okay, I think the rapporteurs agree with that. I see you're both nodding. Thank you very much indeed, Mr. Mamusa. And with that, we can adopt paragraph 2 at first reading. Congratulations to the committee. The paragraphs approved here are, of course, approved at first reading. There is then the entire process which will continue as we receive comments and participation and contributions from states and so on, and then we will subsequently, of course, come back to the draft in second reading. But we have made progress. I return the floor to the rapporteurs for them to present to us paragraph number 3.
Thank you. So with regard to paragraph 3, we already had a discussion, and all the points that were made and agreed upon in the discussion are reflected in the existing draft. All the concepts which are there were already presented, and the purpose of redistributing it was essentially to allow members to take a look at the paragraph as a whole. I would, however, comment that after this, we did receive, I think, 2 requests for reopening 2 notions, and I think both Madame Cleveland and Madame Zyberfor indicated an interest of returning to some formulations. So I think we will oblige them and return the floor to you, sir.
Gracias. Y yo...
Thank you, and I will immediately give the floor to Ms. Cleveland and Ms. Zyberfor for them to make their proposal. Ms. Cleveland?
Thank you, Mr. Chairperson, and again, thank you to the rapporteurs. So I had reiterated to the rapporteurs in light of the revised paragraph 3, a preference for replacing the word expected in intended or expected with reasonably foreseeable, because that is consistent with the language that we use later in paragraph 5. And it wasn't clear to me actually what the rapporteurs thought about that, but that was my proposal. Thank you.
Bien, muchas gracias.
Good, thank you. Ms. Zyberfor.
Thank you very much for giving me the floor. I will be short. Also, I would like to address the second sentence as well. And I was wondering whether we could speak about the protection instead of the entitlement, so that the sentence would read, it concerns the protection of individuals to be free from acts and omissions intended or expected. It ties back to a remark that I made earlier this week, which was about the standards for acts and omissions. Thank you.
Muchas gracias.
Thank you very much. Before I give the floor back to the rapporteurs, there are a few other colleagues who wish to take the floor, so I'll give colleagues the floor first. Don't wave at me. I've seen you. You're all on the list. The first is Mr. de Frouville.
Merci beaucoup.
Thank you very much, Chairman. I wanted to say, first of all, that I agree with the text as proposed by the rapporteurs. The new version of paragraph 3, I believe, takes into account all the suggestions that were made in the first discussion. I just had a comment on the French version, because expected in the French version was translated by escompté, which is extremely strong. It's again this idea of intention, and so we were kind of missing the meaning that the rapporteurs were aiming at with is expected. So in French we would need ayant pour but ou résultat leur d'essai, so we delete escompté. I am a little perplexed at the idea of replacing this with reasonably foreseeable. I don't think it's the same thing at all. When you talk about something that's foreseeable, reasonably foreseeable, you're entering into the realm of probability, which could be quite remote and with quite complex criteria. And I think it would cause us quite a few problems if we had this reasonably foreseeable notion in. So I would prefer to keep the intended or expected. I think it's clearer. As regards to replacing entitlement by protection, I'll make the most of this opportunity to comment on the most recent proposals. I think here that it's not, again, it's not the same thing. I'm struggling with the idea of the right to life only involving requirements in terms of protection. It is the entitlement. It is that people are entitled and they're able to claim this. I think protection, it's kind of quite paternalistic, as though the state has to protect individuals from threats and so on, and from acts and omissions. I think it's very unilateral when we're talking about states' obligations, which in fact cover a broader range, and they are obliged to protect certain things. But I think entitlement is much more appropriate as a term here. Thank you.
Muy bien, muchísimas gracias.
Thank you very much. The next speaker is Mr. Bouzid, please. Mr. Bouzid.
شكرا سيد الرئيس.
Thank you very much, Chairman. I'd like to come back to a life with dignity. We have already spoken about this, and I asked the question whether the state does have the obligation to guarantee this life in dignity. I was told that the obligations are covered by Articles 23 to 33. When I reviewed these articles, I found no mention of the fact that the state is bound to respect the minimum conditions and to guarantee a life with dignity. It's not here. We're not talking about dealing with prisons and preventing violence. The state also has obligations, positive obligations, such as healthcare provided to women and children, for example, food, drinking water, and so on. So there are obligations which the state must respect in order to guarantee a life with dignity. Otherwise, it doesn't make any sense for us to talk about life with dignity. We're not imposing any obligation on the state. Thank you.
Gracias por su...
Thank you for that, Mr. Bouzid. I'll now give the floor to Mr. Boliti. You have the floor.
Chair, 3 points. The first one on the issue of the replacement of entitlement with protection. I would like to echo what has been said by my colleague, Mr. de Frouville. We had a long discussion the last time on the question of entitlement and actually in the previous version, this notion was repeated twice. Now I recognize that the sentence runs more smoothly. I acknowledge that, and it's fine for me, but I would have real problems in replacing entitlement with protection. I am flexible on the question of either we have expected or reasonably foreseeable. I prefer expected, but on the suggestion made by Ms. Cleveland, I can be really flexible. One other point, and this is on the last line, when we say that Article 6 guarantees this right for all human beings without distinction of any kind, including for persons suspected or convicted of even the most serious crimes. Do we need even? I mean, if it's not necessary, I think that the notion is very clear. I mean, everybody is entitled to this right, and perhaps we can get rid of even, but just a linguistic point. Thank you.
Muchas gracias.
Thank you very much. Mr. Benashur, please.
El señor Benashur apareció.
Mr. Benashur has appeared twice on my list, and he hasn't wanted the floor either of the times. Perhaps sometimes I nod or something, and I'm approving, he says. We've got a very alert secretariat here in terms of the request for the floor. The slightest move and you'll be on the list. Mr. Sittlesing, please.
Thank you, Chairman. Coming back to the last sentence, I now notice that we've said including for persons suspected or convicted. I would be for deleting the words suspected or, because that could give the impression that one could impose the death penalty on a person who is suspected of having committed the most serious crimes, when we know that suspicion is not enough. What we need is to go through the due process of law and for the person to be convicted, and then if at all, well, this is practice in any particular state party, then the death penalty is applied. So I would suggest that we delete the words suspected or. Thank you, Chairman.
Muy bien.
Thank you. As I understand it, the paragraph is referring to the right to life in general and to the different forms of deprivation of life, not only the death penalty, but I'll give the floor to the rapporteurs for them to explain things for us. Mr. Shani, Ms. Sanajou.
Thank you. Let me start with Mr. Bouzid. I'm afraid that the paragraph you will refer to is not the right paragraph. It's paragraph 28, which deals very, I think, extensively with issues related to the positive obligations to protect, for instance, against life-threatening diseases such as AIDS and malaria, hunger, malnutrition, extreme poverty, homelessness, and it uses explicitly the notion of dignified existence. So it is dealt with quite extensively. We will get there, and we will see to what extent are the colleagues on the committee happy with it. But there is certainly in the draft, we believe, quite extensive treatment of these very important, in my view, positive obligations relating to life with dignity. Now, with respect to the various issues that were raised, we are, I think, somewhat agnostic about whether to keep even or not. We think stylistically it is better, but it certainly doesn't change anything in terms of substance. With respect to the point made by Mr. Sittlesing on suspected, I would echo the chair's comment that the right to life does not only relate to the death penalty issue. For us, it was actually quite a conscious term that was designed to convey all practices of eliminating suspects that some both police forces and also military forces engage in throughout the world. So we think I think it would be better maybe the addition that we added, the most serious crimes, is what somewhat misled us. But I think this is okay. Now, with respect to the other points that were raised, expected and protection, I sense with respect to expected that some members feel uncomfortable with changing the language. My personal preference would be to retain expected, and because this is a text which is not only used by lawyers in a legal technical sense, it is also a text which hopefully normal human beings have to read and understand. And once we start uploading the text with too many legalistic terms, we are, especially with these initial paragraphs which are introductory, we may end up creating questions of accessibility. Now, with respect to the issue of protection, I also sense that there are some members which would prefer entitlement, and I think at this point in time we would also prefer to keep it as it is. So if the committee would, unless any member feels strongly about it, I think we should approve the text as it currently stands. Thank you.
Muy bien.
Thank you. Thank you very much. So the proposal is to approve the paragraph as was presented, so to retain the words expected, entitlement in the paragraph. Is that okay? That seems to be the case. Thank you. Thank you all for being flexible. With that, then, we can adopt paragraph 3. Okay, we have a paragraph 3 bis, which our dear rapporteurs are going to present to us. So, Nigel, Mr. Shani, you have the floor.
Thank you. So paragraph 3 bis is again a reaction to observations made by members of the committee that we are introducing in paragraph 4 of the general comment, paragraph 2, 4, 5, 6 and 3 of Article 6, but we have no introductory language with respect to paragraph 1. So as a result, we are proposing this text, which I will read slowly, so that all members using other languages than English would have the opportunity to follow. The first sentence is essentially taken out literally from the language of paragraph 1 of Article 6. And the second sentence, and this responds also to some of the concerns that were raised about the obligations, delineating the obligations of states. So the language in the second sentence is extrapolated from Article 2 of the Covenant, the various sub-paragraphs. So I will read it, and then Sir Nigel will make additional observations. You have now 40 seconds. Paragraph 1 of Article 6 of the Covenant provides that no one shall be arbitrarily deprived of his life, and that the right shall be protected by law. It lays the foundation for the obligation of state parties to respect and ensure the right to life, to give effect to it through legislative and other measures, and to provide effective remedies and reparation to victims whose right to life had been violated. Thank you.
Sir Nigel?
Since I'm apparently expected to say something in addition to Mr. Shani's already perfect presentation, I'll just say that obviously this paragraph does what colleagues suggested, which is put down there as a base the rather strong and forceful language of the article itself. And in some ways, as drafters, we were trying to avoid being repetitive, but certainly the language of paragraph 1 of Article 6 is eminently worth repeating for its foundational purposes, and so that's why it's there. And it will be, we hope, a suitable platform then for us to get into more substantive issues very soon, including, of course, paragraph 4, which deals with the death penalty, and separating the two was an agreement we already made 2 days ago, and it's one that clearly is necessary, as we'll see when we come to paragraph 4, which is dealing ultimately with a regrettable exception to or restriction on the right to life that will have to be understood very restrictively itself. But the basic thrust, the basic message is in paragraph 1 of Article 1, and that's in 3 bis, the first sentence. Thank you, sir.
Muy bien, muchas gracias.
Thank you very much to the two rapporteurs. I have several requests for the floor. The first speaker is Ms. Vattenfall.
Thank you, Mr. Chair. I don't know if this will satisfy our wishes, because in line with the discussion we had yesterday, I was thinking of adding before reparation, full reparation. But since this is a general paragraph, so maybe we can leave that out. So I don't feel strongly about it, but I just wanted to express it. Thank you.
Gracias.
Thank you. Mr. Sitru.
Thank you. I just had a small query about the last few words, whose right to life had been violated. If we could be told, is it had been violated or has been violated? But for my part, I perhaps would suggest that we could stop with the word victims and stop it there. We know that remedies can be afforded to the relatives of victims who are already dead, or we can have some kind of reparation, as we've seen in certain cases where people have memorials erected in their honor and all that. So could we, if the rapporteurs could consider this after, of course, other colleagues have given their views, if we could stop at the word victims, or should we continue and say whose right to life has been violated, or is it had been violated? Thank you, Chairman.
Muy bien, muchas gracias.
Thank you very much. Mr. de Frouville. Thank you, Chairman. I would like to support this paragraph. I do think that it's much stronger language compared to the previous version. We look at comment 36 and make it very specific, and also with regard to the reference to death, the death penalty. It's much better wording, and that's clear. I just had one suggestion, and I'm touching on what Ms. Sabat for, and it's about protection. Here we talk about the state's obligations of state parties to protect. We could add protect after respect, protect and ensure the right to life.
Effect, etc. Et là, on a
There are 3 levels of obligations in this manner in terms of human rights. But if we don't have protect, there's a whole dimension of the state's obligations that is left out. It's a very clear sentence, otherwise it does capture the salient points. With regard to the 2 proposals that have been made, allow me to comment on them. I support what Ms. Vortova said, full reparation. I agree with her. Like her, I can live without it. And what Mr. Setul Singh, his suggestion is also important because victims, the notion of victim can, to a certain extent, be extended beyond the initial category of persons whose right to life has been violated. So it is important to have encompass this dimension as well. But once again, I'm comfortable with the text as is. Thank you.
Muy bien,
Thank you very much. And now, Mr. Benashur, you have asked for the floor. Please, sir. Thank you very much, Chairman. I fully agree with the paragraph as first currently drafted. I don't think we should stop after the word victims. It can go beyond that. We do need to specify victims whose right to life has been violated. We do need to keep this. It qualifies it and specifies it. My question is, paragraph 3 bis, is it going to remain independent? Or are we planning to integrate it into the previous paragraphs? Is it going to remain separate as it is presently, or are we planning to merge it into the previous paragraphs? Because they've all got a fairly general nature, an introductory nature, if you like, the first 3 paragraphs. We could do this.
Gracias.
Thank you. With regard to the last suggestion, as I understand it, it's going to become a new paragraph. If we adopt it, the idea is that it become paragraph 4. In any case, we shall continue to work here with the current numbering that we have in front of us, so as not to create any additional problems. Mr. Boussid.
شكرا سيد الرئيس فقط لدي اقتراح.
Thank you, Chairman. I have a proposal. The proposal covers the second sentence where we talk about the obligation of state parties. And here we talk about respect for the right to life and guarantees. And here we need to also introduce the notion of protection. Respect, protect, and ensure the right to life. So I agree with this. The notion of protect should be included.
Muy bien.
Thank you very much. Ms. Seibert-Fort.
Thank you very much. I would like to thank the rapporteurs for the new paragraphs. I think it really strengthens the entire general comment and outlines what comes later on. I am in favor of keeping the text as it is because it adequately reflects the text of the covenant. It says, it repeats the notions that are included, that I referred to before, the arbitrary deprivation as well as the protection by the law. So we have already the protection in the first paragraph, in the first sentence, and in the subsequent sentence, second sentence, refers explicitly to all the notions that are included in Article 2. And it repeats the notions of respect and ensure. So my understanding has always been that the notion of respect and ensure necessarily also includes the notion of protection. If we are now adding it over here, I think we would be giving rise to questions about this in the future. And therefore, I think we should not reinterpret our own covenant and therefore leave things as they are. Thank you.
Muy bien.
Thank you very much. Would anyone else like to take the floor before I give the floor back to the rapporteurs?
Veo que no.
This does not seem to be the case. Then in that case, Sir Nigel, please.
Thank you very much, sir. Yes, definitely a separate paragraph for Mr. Benashur. That was, I think, where we left the discussion anyway on Wednesday, and seeing it textually, it belongs on its own. It doesn't belong connected to 3, and it doesn't belong connected to 4. It stands on its own as a strong statement of principle. The proposal to add the word protect between respect and ensure. I'm not sure that that works. The previous sentence talks about the right shall be protected by law. When we come to paragraph 23, there are 11 paragraphs on the obligation of states parties. From 23 to 33 are paragraphs about the obligations of states parties to protect the right to life. I don't think it's necessary, and arguably it's potentially misleading and confusing, that's the word I'm looking for, confusing, to throw the word in again in the very next sentence. The right shall be protected by law lays the foundation for the obligation on states parties to protect the right. It's tautologous. So I'm reluctant to follow that proposal from Mr. de Frouville and Mr. Bouzid. Ms. Vattenfall's proposal for full reparation, I don't have any objection in principle. It just sounds odd. It's not a remedies paragraph. It's a paragraph again about principle, and I'm not sure one should be contemplating something short of full reparation as perhaps tolerable for violations of other rights, but not tolerable for the violation of the right to life. As to Mr. Sitil Singh's proposal for stopping at victims, I don't have any objection in principle, but I'm not sure that there's a agreement for it. He was right to point out that we used the past pluperfect inappropriately, and maybe if that's to the extent that that's a problem, we can avoid it altogether by talking about victims of violations of the right to life. But I have no particular need either to keep the clause or to let it go. I have a feeling there's probably, I've already heard at least one statement in favor of retaining it, so I think it may be that the center of gravity is for retaining it, but perhaps amended as I've just suggested. Thank you, sir.
Bien, quizás podamos permitirnos un...
Well, perhaps that might warrant a bit more discussion. Would anyone else like to take the floor on that? Please feel free to take the floor again if you'd like to. This does not seem to be the case. That's fine too. So I ask the rapporteurs. I have the paragraph in English. So would you mind, could you tell us how to proceed? I don't want to make a mistake here. Could you tell us, Sir Nigel, how you intend to proceed? Thank you.
Well, I think I was going to propose that we just adopt the text with this, my last amendment to the last clause of the final sentence of the paragraph. But since you mentioned the language dimension and its unavailability, would it be helpful if I read the text out slowly in English as it would be adopted, and perhaps drawing the attention of interpreters to the fact that the first sentence is heavily reproductive, if I may use that term, of paragraph 6 of paragraph 1 of Article 6, the first sentence, and the second sentence pulls on language from Article 2 of our covenant. That may help them in ensuring that there is a faithful reproduction of the language. So 3 bis would read, paragraph 1 of Article 6 of the Covenant provides that no one shall be arbitrarily deprived of his life, and that the right shall be protected by law. Full stop. It lays the foundation for the obligation of state parties to respect and to ensure the right to life, comma, to give effect to it through legislative and other measures, comma, and to provide effective remedies and reparation to victims of violations of the right to life.
Bien, señor.
Thank you very much, Mr. de Frouville. Thank you very much, Chairman. I do think it's always important to hear it in your own language. It made me think again about the issue of victims. Perhaps we're a bit restrictive here. We reduce the scope of victims, in fact, to people who have been killed, whereas the notion of victim is far broader than that, really. There are people who might have been directly harmed by the fact there was an arbitrary execution in the family. An arbitrary execution of a victim affects then other family members who are in the right, who are within their rights to ask for reparation, redress, and also it seems particularly important because it's the right to life. This is someone, once they're dead, can no longer get compensation themselves. It was hearing it in French that made me think of it. Thank you.
Creo que es un...
Actually, that's an important point. We should consider that. And I'd like to give the floor back to the rapporteurs.
I think it's an interesting point too. I think technically, in fact, say the family of victims of unlawful killing would in fact also be victims of a violation of the right to life, and that is how we treat them. So, but I nevertheless understand a little bit the sound of it, and so as I've said, I'm not wedded to continuing past the word victims, which was the proposal by Mr. Sital Singh. It's just that I think there was at least one, possibly more, questions to that proposal. So, in brief, in fact, our practice is consistent with meeting the concern of Mr. de Frouville. On the other hand, I don't think there is any damage particularly done, and if it allows for a certain elasticity of interpretation, that isn't necessarily damaging either, if we were to stop at the word victims. But we're in the hands of you and the committee, sir.
Bien, muchas gracias.
Thank you very much. Ms. Waterval, please.
Thank you, Mr. Chair. Actually, I won't repeat, but I am in agreement with Mr. de Frouville and also support the proposal of Mr. Sital Singh. Just to stop at the word victim, because victims is broader than if you continue to restrict it. Thank you.
Bien, muchas gracias.
Thank you very much. Ms. Sabitfor.
Thank you. I would be in favor of retaining it for the simple reason that Article 2, Paragraph 3 says that states parties undertake to ensure that any person whose rights or freedoms as herein recognized are violated shall have an effective remedy. So there is a specific reference to the violation of the respective right, and therefore I think we should retain it with the understanding, and I think we have repeatedly said it, that victims are not only those who are killed, but those also that we have recognized so far also as victims and have accorded compensation to. And I think by not pursuing this kind of interpretation and cutting it short behind a victim, I think we may give a wrong impression on that. Thank you.
gracias.
Thank you. Mr. Iwasawa, please.
Thank you very much, Mr. Chairperson. I thank the rapporteurs belatedly for the draft. I'm in basic agreement. With respect to the last bit, victims, we're not disputing the scope of the right to life. We're just debating how we express it. And with the this understanding will be recorded in the summary record. I think for a layman, I come back to the point made by Mr. Shani. I think it's easier to understand if we have victims of the violation of the right to life, but we put in the record that this includes. I mean, we're not narrowing the interpretation of the victims here. Thank you.
Bien, muchas.
Thank you very much. I have 4 further requests for the floor. Mr. Vardashvili, please.
Thank you very much, Chair. And first of all, let me also thank the rapporteurs for the presented drafts. I'll join the colleagues who supported the language proposed by Sir Nigel. I think it's right to refer to the remedies, and we're quite safe to refer to the victims as well. We may also include a footnote if we are concerned with the understanding of the term victim. Then we could insert the footnote which would refer to our case law, and that might respond to the concerns of those who believe that the victims may be understood in a more narrow sense. Thank you.
Muchas gracias.
Thank you very much. Ms. Cleveland, please.
Thank you, Mr. Chairperson, and thank you also to the rapporteurs. I think we could go either way on this. I think that looking at the sentence itself says earlier, it references the obligation of state parties to respect and ensure the right to life. And then to give remedies and reparation to victims, it seems to me obvious that victims refers back to those whose rights to have the right to life respected and ensured are the victims that we're talking about. And given that, I don't think it's necessary to reiterate that the right to life has been violated, and I think it could give rise to the inference that Mr. de Fruville was concerned about, even though that's not what we mean under our own jurisprudence. Thank you.
Muchas gracias, señor.
Thank you very much, Mr. Politi.
Chair, I wish simply to congratulate the rapporteurs. This is an excellent paragraph, and I feel comfortable with it. With regard to the last part, I think that the expression that refers to reparation to victims of violations of the right to life is capable of encompassing and taking care also the concern expressed by Mr. de Fruville. I'm not particularly in favor of footnotes. I think that that would not be the solution. One possibility could be, but I say I'm very comfortable with the paragraph as it is, to say a reparation to all victims of violations of the right to life. But it's just a suggestion that I make in case the current formulation that I share would not satisfy completely the members of the committee. Thank you.
Bien, tengo 3.
I have 3 further speakers on my list. I'd like to include myself as number 4. Perhaps I'll need to ask for the floor at that point, but I'll speak last in any case. And first on my list is Mr. Setul Singh, please.
Thank you, Chairman. Actually, after listening to Sir Nigel, I was happy with the way he rephrased it in English when he said reparation to victims of violations of the right to life. In English, it sounds well, but I'm not sure whether, at least I understand and know know French. In French, it may sound a little bit ambiguous, and I don't know what it sounds like in other languages. So it may be a question of translation and what kind of impression it gives in other languages. Thank you, Chair.
Muy bien.
Thank you very much, Mr. Benashur. Thank you, Chairman. Well, earlier I said that I didn't actually agree with stopping after victims. But now that I've heard Mr. de Frouville, I am hesitating. And I actually don't hold the same opinion anymore because he reminded me that in our case law, and I remind you in particular the Algerian case of forced disappearance, in all of these cases, reparation that was given to the indirect victims. It's true. In other words, the real victim had disappeared. We recognized that the disappearance of this person constituted for the state a violation of Article 7 of the covenant, but we didn't give reparation, so to speak. The real reparation was given to his family, the spouse, the brother, daughter, etc. So, bearing that in mind, the wording that Mr. Politi suggests is a good one because it allows us to extend the scope of victims. We can say reparation to all victims, in particular indirect victims whose right to life has not been violated. That's the case of the person who disappeared. But it's an indirect manner of giving the family, etc., reparation. Thank you.
Gracias, señor.
Thank you, Mr. de Frouville. Thank you, Mr. Chairman. It is indeed difficult to grammatically analyze this in two languages. It was the French that shocked me and brought me to my comment. The French version would be
aux victimes dont le droit à la vie a été violé. Alors, la victime dont le droit à la vie...
The victim whose right to life has been violated is the person who was the victim of a summary execution. They're dead, they can't receive reparation. If the sentence itself is contradictory, that is a problem. Reparation has to be given to those who have been harmed indirectly by the wording needs to be different in French. I was going to take the floor, but I'd like to give the floor first to Mr. Posatis.
My pleasure. I'm sorry. I was hesitating on taking the floor, but because I followed this discussion, first of all, thank you to the rapporteurs. Thank you very much. I just like to remind our colleagues that here we are in the initial paragraphs. And I think this paragraph is very forceful and strong and concise and should remain as concise as possible. What I mean is I don't think right now we need to get into a discussion of who victims are. And I would be for just leaving the formulation proposed by Sir Nigel of violations of right to life. I would be also comfortable with just stopping at victims if that would help the French translation. I think the draft comes back to the issues of reparations and very extensively near the end, and remedies and all that. So maybe right now just keep the forcefulness of this paragraph. Thank you, and excuse me for taking the floor from you.
Bien, muchas gracias.
Thank you very much. Now I'd like to say something on a personal note, if I may. It's not a proposal. This is just my personal reflections. Let me say the following. Reparation is for victims, including victims whose right to life who cannot receive it directly. For example, in international courts, it establishes an amount of money, which is the compensation, and this goes to the victim's family as part of what they receive, but it is given in favor of the victim. Also, as has been said, there is a condition placed on a victim as we understand it, family members are victims under another article, Article 7 of the Covenant. And in the case of forced disappearances, it's a good illustration of this, I think. I believe that it doesn't hurt if we finish the paragraph with victims, and then all victims are covered, and we don't have to then specifically refer to persons whose right to life has been violated. We actually say that higher up in the text. So I think that we should perhaps stop after victims. But it's just my personal opinion. I'm certainly not putting a proposal on the table. It's in your hands. And I'd like to now hand back to the rapporteurs for their reactions to what has been said. So Nigel.
Yes, I'm not sure we're able to square the circles. I mean, there just really are two competing views, it seems, unless I detected that Mr. Politi had a way through whereby we would refer to all victims of violations of the right to life, indicating that it is, implying at least that it's not necessarily just the individual whose life has been lost. When dealing with disappearances are a bit confusing there because Article 7 is violated anyway, and when positive obligations to investigate are ignored, then that can be an Article 7 violation as well, but it can also be an Article 6 violation for the families. So the disappearances argument is a bit difficult. We have three choices, it seems to me, sir. One is to just take the existing text and stop at victims, which some colleagues would prefer. Those who would prefer to basically stay with the existing text, but without the past pluperfect. Let's say victims of violations of the right to life. And one which may be a compromise text, and if it is, I'm absolutely fine with it, that we would refer to reparation to all victims of violations of the right to life. And we have to return the problem, well, Mr. Shani wants to come in and maybe he can solve it better than I can.
I'm afraid I cannot, but I just wanted to reassure members that we are dealing with the issue of remedies later on. Paragraph 29, for example, does deal with the issue of effective remedies and does suggest, for instance, that families are also due to reparations. So there is actually treatment of the specific issue later on. So I associate myself with the comment by Ms. Patsaris that we do not have to resolve or to deal in very minute details with the issue at this point in time. I'm fine with all three proposals which are on the table, and maybe if members could indicate their preference, we could determine how we want to go about this. Thank you.
Bien.
Okay. I imagine that nobody is very seriously opposed, but given that the rapporteurs aren't insisting emphatically on one particular version, we could perhaps ask colleagues if the rapporteurs had said we are insisting on this particular position or this is the version that we want to, that we prefer, then we would of course go with that. But if you'd rather get a sense of the majority feeling, then we can, well, kind of take an indicative vote. We're not going to vote. We don't vote on general comments. I just want to flag that this is a public meeting. But just so that we can get an effective idea, a proper idea of people's preferences. Mr. Iwasawa, were you asking for the floor?
Yes, I'm not in favor of taking a vote on this particular issue. I can go either way. I think either you or the rapporteur should propose one version, and then we can go along. Thank you.
Gracias. No.
Thank you. No, I wasn't going to make us vote properly. I just wanted to get the general feeling of the committee members, just to be sure. I wasn't going to have us voting on anything, but I will give the rapporteurs to make the proposal that they prefer. So I'll return the floor to them. Sir Nigel, please.
It's not quite the proposal that I, or perhaps even we, most prefer, but it's the proposal that I think best reconciles the various positions that we would prefer, and that is the one proposed by Mr. Politi, which is reparation to all victims of violations of the right to life. That is the proposal we would prefer. Thank you, sir.
Bien.
Fine. So that's a specific proposal then. Can we accept this, colleagues? Can we accept this proposal? It seems that we can. I'm struggling a little bit, but I can accept it. So that is adopted. Congratulations. That means we can adopt 3 bis. This will then become paragraph 4. Now, let's move to paragraph 4 of the draft that we have. We will continue to work with the original numbering. Paragraph 4. I return the floor to the rapporteurs.
Thank you. So paragraph 4, we've already discussed on Wednesday, and there were some comments made by members that were incorporated into the text. We have introduced, instead of the previous language, the language of in countries which have not yet abolished death penalties. We replaced the word exercise with the word applied. And there was an interest in reflecting or emphasizing the notion of arbitrary deprivation of life, and as a result we did change the second sentence, and it now reads, and I will read it slowly: the prohibition on arbitrary deprivation of life contained in Article 6, paragraph 1 further limits the ability of state parties to apply the death penalty. Now, the only issue that we left in square brackets for the committee to decide upon, well, the committee decides upon everything, but on which we felt we did not have sufficient guidance from the committee to propose a text for voting, is whether we want to deal with the issue of the most serious crimes explicitly in paragraph 4. Originally, we thought that this may be covered by the notion of the strictest limits, but some members have expressed an interest in also explicitly referring to that. During the last session, I expressed some reservation because of the allusion to the most serious crimes in paragraph 3, but in the interim, paragraph 3 bis has emerged, and it somewhat reduces my concern about repetitive reference to most serious crimes. So at this point in time, if members would like to see that in, I think we would gladly oblige with this now, Nigel. Well, we would obediently comply.
Muy bien.
Okay. I see some due obedience on the part of the rapporteurs, and I thank them for that on behalf of the rest of the committee. I give the floor to Mr. Bouzid.
Thank you very much, sir. I just have a proposal in form, and the aim is to reach more accuracy. We are talking here about in countries. I believe that we have to say in state parties. When we say in countries, it means that the countries which have not ratified the covenant, but we are here addressing the state parties which ratified and adhered to the covenant. So we say in state parties and not in countries. Thank you.
Gracias.
Thank you. Well, the text is lifted directly from the covenant. It does refer to countries, that part of the text, and not state parties. Mr. Siddlesing, please.
Thank you. We thank the rapporteurs for proposing this paragraph. I would be for removing the brackets of concerning for the most serious crimes. I would be for introducing these words. I do realize that there would be a repetition of most if we say it shall be applied only in the most exceptional cases for the most serious crimes. Should we say exceptional cases? That I would be grateful for clarification from the rapporteurs on this issue. But I come to the next sentence where I have some hesitation about the word further. If we say the prohibition and arbitrary deprivation of life contained in Article 6, Paragraph 1, further limits the ability of state parties to apply the death penalty. In my own view, Article 6, Paragraph 1 is the fundamental paragraph enunciating the right to life. And as we've already said in Freebis, it's the one where it is said that no one shall be arbitrarily deprived of his life. So what I'm questioning is actually the word further, that it's not as if 2, 4, 5, and 6 come first, and then paragraph 1 comes as an adjunct or comes as if it were less important. For me, it's the basic right, and we should not say further. If we want to repeat the sentence, it's okay, but I would be for removing the word further. Or else, well, later on we go into the more philosophical and practical discussion. So that's my suggestion, to keep for the most serious crimes and to remove the word further in the next sentence. Thank you, Chairman.
Bien, muchas.
Thank you very much. Mr. de Frouville, please.
Merci beaucoup.
Thank you very much, Chairman. I would like to thank the rapporteurs for this new version. I do think it fully encompasses the discussion that we had, and I support the changes. I wouldn't actually keep for the most serious crimes. I think it's more explicit to say the most exceptional cases. So I wouldn't keep for the most serious crimes. I think the most exceptional cases better corresponds to the committee's jurisprudence. And I do think we do need to keep this idea, again in reference to the committee's jurisprudence, that there are cases where the imposition of the death penalty is an arbitrary deprivation of life, and that therefore might fall under paragraph 1 of Article 6. Of course, I would keep this sentence, I think, unless I've misunderstood the sentence. Thank you.
Muy bien, muchas gracias.
Thank you very much. Ms. Cleveland, please.
Thank you, Mr. Chairperson. I personally like the most serious crimes and prefer it to the most exceptional cases because it is more explicit about the meaning but I actually asked to take the floor in response to Mr. Satulsing's point about the second sentence and the fundamental nature of the obligation in Article 6, Paragraph 1 for the death penalty, as well as other aspects of the right to life, which led me to wonder whether it might make sense to move the content of the second sentence so that it's the first sentence of the paragraph, so that it would follow 3 bis by noting that the prohibition on arbitrary deprivation of life contained in Article 6, Paragraph 1 limits the ability of states parties to apply the death penalty, and then it would continue and say paragraphs 2, 4, 5, and 6 of Article 6 of the Covenant further set out specific safeguards for ensuring that in countries, etc. It's just a suggestion. I'm not wedded to it. Thank you.
Muy bien, muchas gracias.
Thank you very much. Mr. Politi, please.
You, Chair, with regard to the reference to the most serious crimes, I think that I don't know whether I was the only one to do it, but I suggested at the last meeting the inclusion of the reference to the most serious crimes for reasons of consistency with other paragraphs of the draft, in particular paragraph 20. I'm fine also with reference to the most exceptional cases and under the strictest limits, but in paragraph 20, I think that the reference is to the most serious crimes subject to a number of strict conditions. This is the expression that I suggested. I don't feel too strongly about it. I would prefer to, naturally we can change paragraph 20 when we come to that, but my preference would be to stick to this expression that is already contained in the draft, in particular in paragraph 20. And since I have the floor, I am attracted by the suggestion by Ms. Cleveland concerning the change of the position of the 2 sentences. In fact, the reference to further it's a reference that right now suggests some sense of imbalance between the paragraph 2, 4, 5, and 6 that are mentioned at the beginning, and then we go back to paragraph 1. So I think that it's a road, a way to be explored, that of changing the position of the 2 sentences. Thank you.
Muy bien.
Thank you very much. Ms. Vattenfall, please.
Thank you, Mr. Chair. Well, I support the paragraph as is, but I would opt for the most serious crimes because that is the language used in paragraph 2 of Article 6. And I was wondering, and the rapporteurs will correct me, I was wondering if this is not a paragraph to introduce the mandatory death penalty. I know that it's already in paragraph 39, but maybe it could be introduced in this paragraph. Thank you.
Muy bien, muchas gracias.
Thank you very much. Mr. Benachot, please.
Merci, Monsieur le Président.
Thank you, Chairman. I'd like to support the proposal made by Mr. Bouzid earlier to replace countries with states parties. Why? Well, because in the Covenant it's true, the wording is in countries which. But in the Covenant, when we talk about countries, it's obvious that we're talking about states parties to the Covenant. We're within the Covenant, whereas here we are interpreting the Covenant. And I think we would be better using the expression states parties to express the fact that this applies to states which are party to the Covenant. We can't do any other. The issue of the abolition of the death penalties isn't the affair of countries, it's the affair of states. Mr. de Frouville, a short time ago, in another discussion, reminded us that it is the French state which has taken the initiative of abolishing the death penalty, whereas the country itself wasn't necessarily on board. So I think that there are two reasons: the responsibility of the state in abolishing the death penalty and the fact that we are here interpreting the covenant and should, I think, use the words proposed by Mr. Bouzid.
Muy bien, muchas gracias.
Thank you very much. Ms. Abbott, 4, please, to be followed by Mr. Iwasawa and then the rapporteurs. Ms. Abbott, 4, please.
Thank you very much, Mr. Chair. I was thinking about the order, and I have the feeling that if we reverse the order, it would weaken the content of these all. Because in a way, the sentence as it's now, it says, on top of these very specific requirements, there is even more. Whereas if we reverse the order, it could be interpreted as that we have this and Article 6.1, and that this has been spelled out like lex specialis in the subsequent paragraphs. Whereas I think that apart from the very specific treatment, there's even more which needs to be considered under Article 6.1, paragraph 1. Though I understand the reasoning, I'm a little bit afraid that the changing of the structure would weaken this. Perhaps I understand also the uneasiness by Mr. Siltusing about the term further, but I still think that it expresses exactly what I've said, that on top of what we have in the paragraphs 2, 4, 5, and 6, we have to consider paragraph 1. Perhaps the rapporteurs, as one native speaker at least, could find perhaps a better word than further in terms of additional or something like that. Thank you.
Muy bien, muchas
Thank you very much. Mr. Iwasawa, please.
Thank you, Mr. Chair. I'm addressing also the order of sentences, first sentence and second sentence. And along the same lines as Ms. Zybert 4, I think we should keep the order as is. I think there is a logic, as explained by Ms. Zybert 4. The specific safeguards in 2, 4, 5, 6 are obvious. And I think we should stress that first, and then we add this second element because it limits the ability of state parties to apply the death penalty. I don't know what what word would be most appropriate, further or in addition or also. I leave it to the rapporteur. Thank you.
Muy bien.
Okay. Dear rapporteurs, you have the floor.
It's been a very good discussion in which colleagues have really tried to unravel what is something that isn't easy. But let me start with something that is reasonably easy, with respect to Mr. Bouzid and Mr. Benachur. I think we have to have really good reasons to depart from the text. And that's something we learned in the last, this week, that every time we depart from the text, there's a risk of misunderstanding. And the text of the covenant talks about in countries. And there may even be some legal significance to that. It may even be that that can be invoked also as a statement of general international law, not just a specific covenant right applicable to states parties. And I'd be reluctant for us to say anything that might suggest anything differently, especially as there have been repeated General Assembly resolutions going in the same direction. So while understanding the juridical point that they're making as far as the technicalities of the covenant is concerned, I think we just might end up creating misunderstanding if we now talk about states parties only. The issue of the most serious crimes, It's there in so many paragraphs. One we've already approved. It's in paragraph 20, I think. It's in paragraph 37, and it's in various other paragraphs as well. I don't really see the need to say it here, and not least because we're then going into all the different elements of Articles 6.2 to 6.6. And if you start with one, then why not carry on with all of the others and deal with them up here? So I actually think it's superfluous, which is why we use the language most exceptional cases. That said, I acknowledge that quite a lot of colleagues do like it, maybe as perhaps the most important dimension of the restrictions. But if we were to include the words in square brackets, I wouldn't want it to be at the expense of in exceptional cases. It has to be both, not just the language of most serious crimes. Finally, and what I've just said also applies, I guess, to Ms. Vattenfall's point, which is a point of how we interpret the most serious crimes and how we interpret arbitrary. We get there. We deal with the mandatory death penalty, but to put it up here, I think would be to give it disproportionate attention as a foundational principle. Though I think it's a very, very important point, and it's a great achievement of the committee to have arrived at its position of turning its face against the mandatory death penalty. So that just leaves the question of the relevance of Article 6, paragraph 1. And there Ms. Seibert got our intention exactly. That essentially Article 6, paragraph 1 is overarching and residual. That just because we have certain safeguards in 2 to 6 doesn't mean that that's the be-all and end-all of it. And the problem with that residual, that it's both overarching and residual, and so words like additional and also don't quite capture that element. And I'm not completely wedded to further. It's just that I haven't found a better word than further to capture the notion of overarching and residual. And I think there are both words are there. I mean, you could come back to me and say, well, why don't we put in overarching and residual? And one wants to be a little bit economical and not to mention General Assembly word limitations. So at the moment, I can't think of anything better that better reflects the intention than the word further. And of course, it follows that it has to it has to follow the previous sentence, not precede the previous sentence. And I've already seen, I think, Ms. Cleveland nodding to points that other colleagues have made in that sense. So I guess I'm just saying in the end, sir, we keep the text as it is, and while I myself would not necessarily go for adding for the most serious crimes, I think there is a general feeling in the committee that it should be there, and I certainly don't want to express a strong rapporteur preference against it. Thank you, sir. I don't know, Mr. Shani Mr. Shani does have things to add.
Not a lot, and I'm also conscious of the time. I'll just note that I'm not sure. It will be good to perhaps again get a sense of the committee whether there is an interest in. I'm not sure, as Sir Nigel, that I think we may be evenly split on this as well, on the most serious crimes. In terms of the order, I mean, it wouldn't work replacing the articles also for reasons related to the structure of the paragraph. So it's a little bit a table of contents. So 3 bis was introduced as to offer the table of content for paragraph 1, and now we're with the table of content for the remaining paragraph. So it would really disrupt the editorial structure if we play with the order here. I'll stop here.
Bien.
Thank you very much. I have a request for the floor. Mr. Sijo Singh, please.
Thank you. I'll be very brief. After listening to Sir Nigel, what I find is that overarching and residual are at antipodes. That is, and further, to my mind, gives more an impression of residual than overarching. So my suggestion was to do away with the word further altogether and not put the word further, so that then it's open. Then it doesn't mean either overarching or residual. So we delete the word further. That's my proposal. Thank you, Chairman.
Bien, creo que esa no es la idea de los...
I think that was the idea of the rapporteurs. Ms. Basatis, please.
Thank you. I just wanted to come back to the most serious crimes, and after listening to Sir Nigel Rodley about how many paragraphs this is referred to, it might be for the interest again of economy. It might be better to just take it out, and I would be in favor of just deleting that in this paragraph. Thank you.
Bien, déjenme...
Okay. Let me try and do this in 1 minute. I think we've heard sufficient explanations, and some of them, well, all of them very convincing around this paragraph. As far as I view it, I think that there are sufficiently convincing explanations for us to approve of the paragraph. We've also clearly taken on board what everyone said the previous time. Could I ask the committee whether we are able to accept the paragraph as it stands? That seems to be the case. Fantastic. Thank you very much. So the paragraph, Mr. Shani?
No me diga que usted...
Don't tell me that you're opposing your own proposal.
With or without the square brackets? This is the question.
No. La idea era no...
The idea was not to include what is in square brackets, taking into account that there are references to the most serious crimes in other paragraphs later on, and the entire general comment needs to be read as a whole, of course. Thank you very much. I would truly like to congratulate the rapporteurs very warmly indeed for the work that they have done. They've brought these 4 new paragraphs which exactly encompassed the debate among colleagues in previous occasions, which does show a great deal of respect for everybody's opinions here. And I'd really like to commend committee colleagues as well for also having been flexible when the paragraphs didn't exactly reflect what they wanted to see. So with that, we can close our discussion during this meeting of the draft general comment on Article 6. Once again, my thanks to the rapporteurs, to Mr. Shani, to Sir Nigel for the work done. Now, in addition to its general comment, as you know, the committee has a great deal of other work on its plate. So if I can ask colleagues to read the reports that are going to be presented to us by the rapporteurs on follow-up, the concluding observations, Ms. Cleveland, and the report from the rapporteur on follow-up to views, Mr. Rodriguez-Recia, because this will be dealt with on Monday morning, also in a public meeting. And bear in mind that you have folder 4. You have folder 4 on communications on inadmissibility decisions. And Monday, we have until 1 for those of you who want to reopen any of those decisions. So we have until Monday at 1 for that. Colleagues, we've had a very demanding week of work. I'd like to congratulate you all for a good job well done. Have a lovely weekend. Have a lovely weekend to the pastry writers, to all of those of you in the room with us, to the interpreters, conference services, the secretariat staff. See you on Monday at 10 o'clock. The meeting stands adjourned.